or on the executive order or on the IRA definition. AN respects the law as it exists, of course, but as an organization, we don't engage in litigation, we don't engage in excuse me, we don't engage in litigation, and we don't engage in legislative advocacy as an organization. Our aim in holding this webinar is to provide you, the members of AN, with an opportunity to learn and to probe on the issues raised by the EO in the hope that it will help you become more informed and more confident when you engage in these discussions on your campuses. So before I turn it over to Miriam to introduce the panel, I just want to provide some quick housekeeping details. The program will run as follows. After Miriam introduces the panelists, she and I will take turns asking the panelists to respond to several questions. Each panelist will have a chance to respond to each question. During this portion of the program, which will last approximately 20 to 25 minutes, each of your audio functions will be muted, and the chat function on the Zoom screen will also be muted. That is, you won't be able to post questions or comments during this period of the program. You'll see, however, that in the chat box, links are posted to Title VI, the EO, the IRA definition. You can access these at any time during the webinar if you so choose. After the panelists offer their remarks in the opening session, we will then split up into 3 separate breakout groups. Never done this on Zoom. It's actually pretty neat. With the click of a button, our tech support team will automatically transport each of you into a new window on your screens, where you'll be grouped with the other participants as well as one of the 3 panelists. Unlike at a real conference where you would need to stand up and walk, maybe eat something, schmooze, go to the bathroom, here it's nearly instantaneous. So the breakout sessions are your chance to ask questions of the panelists. We'd like to keep these informal, and so here your audio and chat functions will be enabled and will be for the portion of the breakout sessions of the webinar. Finally, after about 20 minutes, each of us will automatically be zoomed back into the main room where the panel will reconvene and offer some closing remarks and, time permitting, respond to some additional questions that weren't able to be addressed during the breakout sessions. I just want to take an opportunity to note that the opening portion of the webinar as well as the closing portion will be recorded so that we can make the program available to the members of AN and others who were not able to attend. The breakout sessions will not be recorded. These are off the record. Miriam?
Well, thank you so much, Mike. Welcome, everybody. Welcome to our panelists. Many of you know our panelists. They are esteemed members of the professional community. Introducing them would take an entire hour of our time, given their many, many accomplishments. But I'll just say a word about each of our panelists. Elisa Lewin is the president and general counsel of the Louis D. Brandeis Center for Human Rights Under Law, which is a nonprofit established to advance the civil and human rights of the Jewish people. She began her career in the law in Israel, where she clerked on the Supreme Court for Deputy President Justice Menachem Ilon. She's the immediate past president of the American Association of Jewish Lawyers and Jurists, and this past January, that association awarded her its Distinguished Pursuit of Justice Award. Many of you are likely familiar with Elisa's important work in the area of civil litigation and anti-discrimination and criminal defense. In 2014, she argued before the US Supreme Court in Zivotofsky v. Kerry, also known as the Jerusalem Passport case. Benjamin Ryberg is Chief Operating Officer and Director of Research at the Lawfare Project, a global network of legal professionals committed to defending the civil and human rights of the Jewish people and the pro-Israel community and to fighting discrimination. Back in 2013, Ben was profiled in the Jewish Week's 36 Under 36 list of young visionaries. He's a seasoned public speaker, and he received his Juris Doctor from the Benjamin N. Cardozo School of Law. And Joe Cohen is the Legislative and Policy Director at the Foundation for Individual Rights in Education, or FIRE, whose mission is to defend and sustain the individual rights of students and faculty and the essential qualities of liberty on US campuses. Joe earned his Juris Doctor from the University of Pennsylvania Law School. He has served as a staff attorney at the AIDS Law Project of Pennsylvania, earning many accolades for his work. Joe is a former staff attorney for the U.S. Court of Appeals for the Third Circuit, and he also served as the interim legal director for ACLU affiliates in Nevada and in Utah. So welcome to everyone. Thank you, panelists, for taking the time to join us today. And I will turn it over to Mike for the first question.
Thanks, Miriam. Okay, so the first question to our panelists, and why don't we go in order in which Miriam introduced the panelists. There has been considerable debate over the Trump administration's executive order on combating anti-Semitism. What is your position on the EO and its likely impact on campuses? Should we consider it a helpful tool for Jewish and Zionist students facing harassment and discriminatory action?
Thank you, Miriam and Mike, for inviting me to participate in this program and this really timely topic. I think the executive order on combating anti-Semitism is often misconstrued. It's important, therefore, to understand exactly what it does and does not do. The executive order did not suddenly define Jews as a race. It does not make it a crime to say something anti-Semitic, and it does not prohibit criticism of Israel. What the executive order does is it links the International Holocaust Remembrance Alliance definition of anti-Semitism to Title VI of the Civil Rights Act of 1964. Title VI prohibits discrimination on the basis of race, color, and national origin in programs and activities that receive federal funding. Although Title VI does not mention religion, both Republican and Democratic administrations, both the Bush and Obama administrations, formally recognize that religious groups such as Jews, Sikhs, and Muslims, who have shared ancestral and ethnic characteristics, are also protected under Title VI. So recognizing that Jews are protected by Title VI, which the executive order does, was nothing new. What is new about the executive order is that it requires all executive branch agencies and departments charged with enforcing Title VI, not just the Department of Education, to apply the IRA definition of anti-Semitism when they evaluate discrimination claims. It's this adoption of the definition of anti-Semitism that's caused all the ruckus. So why is the IRA definition important? It's important because many people today have a difficult time recognizing anti-Semitism that doesn't directly resemble the anti-Semitism of the Holocaust. When people see a swastika, they know it's anti-Semitic. Similarly, when they hear a Nazi or a white supremacist, they recognize that as anti-Semitism. But many people forget that anti-Semitism existed for centuries before the Holocaust. Anti-Semitism has always been about demonizing, marginalizing, and excluding Jews. Each generation finds a different excuse to justify its Jew hatred. Jews have been maligned as the Christ killer, the capitalist, the race polluter. Today, when society views colonialism and apartheid as the greatest evil, the Jew and the Jewish collective, the Jewish nation state of Israel, are blamed. The IRA definition is necessary to educate the public and to get them to understand that today's anti-Semitism seeks to marginalize and demonize those Jews who embrace the right of Jewish self-determination. Nazis and white supremacists are not the only anti-Semites in the world today. Those who pressure Jews to shed the national ethnic component of their Jewish identity, those who demand that Jews abandon their sense of Jewish peoplehood and historic yearning for Zion as the price of admission, those people are also anti-Semites. In America, the First Amendment protects your right to express yourself as a bigot. Nothing in the executive order changes that fact. The First Amendment, however, does not insulate those who make racist or anti-Semitic comments from being labeled as racist or anti-Semites. The IRA definition provides the necessary guidance so that all anti-Semitism can be recognized, labeled, and forcefully condemned.
Thank you, Alyza. Ben?
Well, first, thank you, Miriam. Thank you, Mike. Thanks to AN for having me. I'm thrilled to be here and to join my two very distinguished panelists. And thank you to all of you who joined today. I sort of expected this to happen. Alyza, in her very excellent response, covered a fair amount of what I think is most important and what I was going to touch on. But what I want to highlight is, and what I think is the most potent aspect of the executive order, is that how it puts universities on notice that anti-Semitism, as Alyza said, must be treated the same way as other forms of discrimination, and it defines for those universities. So I think what this can do, now that universities have this framework, hopefully educate campus officials and faculty more on what anti-Semitism can look like, what these modern manifestations of anti-Semitism are, so they will endeavor to respond appropriately when such incidents are brought to their attention, but also, frankly, to scare them a little bit if they haven't really been very active in addressing these types of issues over the years. To know that now that the federal agencies tasked with enforcement will be looking at these, and that if the Department of Education does open an investigation into a particular school, this is what they will be looking at. So my hope is that this will serve to deter willful blindness and deter inaction at these universities that we've seen go on and on. And I also, another point Lisa made that I want to really emphasize, that I think everybody out there who is currently working within academia should really be aware of and should be well versed in, is the point about the First Amendment and how the executive order does not ban or penalize any specific type of speech. That is the most frequent attack we see against the executive order. It's very similar to the regular attacks we see against anti-BDS laws, and the argument simply holds no water. It would only really show up if a school decided to act in a way that it did violate the First Amendment, in which case someone could file a lawsuit and enforce their rights under the First Amendment. But the executive order itself simply does not say you cannot make an anti-Semitic statement, disgusting anti-Semitic statement even, and it certainly does not say that anything one says that's critical of Israel is going to get you kicked out of school. But rather, it obligates the university to respond in a meaningful manner when these manifestations of anti-Semitism reach a level that is so severe and pervasive that it is creating a hostile environment for students. And indeed, to respond to that before it gets to that level, because that is the level where legal action is appropriate.
Well, I guess I am leading the caboose here and slated as the dissenting voice. So I'm going to file my dissent now. Thank you for the introduction, Miriam, and thank you, AAN, for hosting this event. I want to, before I really dive in for a moment, just to make sure folks understand that FIRE is first and foremost a free speech and due process organization. And we deal with those issues in a lot of contexts, not just this context of how to address anti-Semitism. But the single most common form of campus censorship, the single most common rationale for punishing a student for protected speech is overbroad anti-harassment policies. Not just on this Israel thing, but whether it's race or gender or any of the other protected classes, there is unprotected harassment, but so many codes do not use the legal standards of severity, pervasiveness, but the EO doesn't either, first of all. With that as the general broad backdrop, I think the first place to begin is to say that, at least from FIRE's perspective, it's a no-brainer that anti-Semitism on college campuses is a problem that warrants robust responses from institutions themselves and from government actors. So when evaluating the EO, we really take it apart into the different components. And the first component that Alyza was discussing, the part about making it law as opposed to just policy, that Title VI confers federal government jurisdiction, at least in the cases that are about shared ancestry and cultural stereotypes. FIRE completely agrees with. We advocated for that as our alternative solution, as at least one slice of our alternative solution. Was pleased to see that in there. From that perspective, the EO, that component of the EO, we think will be very helpful. The part about adopting the definition, however, here's where my dissent comes in. I think it poses tremendous First Amendment problems. not because it says flat out, you may not engage in this behavior, but what it does is it gives every school in the country the incentive to do that, because they aren't going to get in trouble with the federal government for overstepping here. They're going to get measured by the federal government for whether or not they're taking strong enough action against things that are now deemed anti-Semitic. The way, you don't see university presidents consistently saying it's racist, but you more often see the expulsion of the student, say in Oklahoma, for the racist chants, etc. The thing about, and I'm trying to wrap this up quickly because I know we have only limited amount of time, is that we don't historically define what is racist, what is sexist, what is anti-Semitic. We bar discrimination based on broad classes, race, religion, gender, etc., and we leave it to people on the ground to evaluate the facts in their context. And in the next segment, we'll get to see how this definition has been used precisely how I am describing over and over and over again to claim just the presence of voices critical of Israel is a violation of Title VI that schools must clamp down on if they don't want to risk all of their federal funding to be pulled. And we'll talk about that, I guess, in just a few minutes.
Well, thank you to all of you. I'm going to ask the second question. And our second question is, and we also have a little poll coming up for our audience to respond to on the screen. But our second question is, Jewish and Zionist students and organizations representing them have in recent years filed a number of Title VI complaints with the Department of Education's Office of Civil Rights. Can you offer your perspective on one or two of these complaints that have been filed? So Alyza, we'll start again with you, please.
So New York University, NYU, which is my alma mater, is sadly a campus where I believe that a Title VI complaint was warranted, and there is currently an OCR complaint pending against NYU. There are many incidents that took place there, but I'd like to focus on one. 2 years ago, 53 student organizations at NYU signed an agreement to boycott not only the state of Israel, but to boycott all pro-Israel student groups on campus. The 53 student organizations representing a broad swath of the campus community resolved that they would not co-sponsor events or engage in dialogue with any pro-Israel organizations. In response, the university hired a professional facilitator to facilitate a dialogue among representatives from the 53 groups. The facilitator explained to the students that she had gathered them there to dialogue, not to debate. A debate, she said, is where I try and convince you I'm right, you're wrong. A dialogue, she said, is where we recognize that everyone has a different perspective and we respectfully share and listen. Well, what was intended to be a 1.5-hour dialogue turned into a 2.5-hour discussion about whether the anti-Zionists would even deign to dialogue with the Zionists. We didn't want to jeopardize our student funding, they said, so we came to this meeting, but we're not about to dialogue with them. And after 2.5 hours, the facilitator gave up. So I ask you, what message does this send to the pro-Israel students on campus? It says to them, if you want to join our campus community, if you want to be included as a full-fledged member and demonstrate with us on climate change, immigration, women's rights, or LGBT rights, or if you even just want to dialogue with us, we'll accept you on one condition. Check your support for Israel at the door. Shed that part of your Jewish identity, and then you can join us. The problem is that Zionism is as integral to Judaism as observing the Jewish Sabbath or maintaining a kosher diet. Not all Jews observe Shabbat or Kashrut, but those who do so as an expression of their Jewish identity. Similarly, not all Jews are Zionists, but for many Jews, identifying with and expressing their support for the Jewish homeland is also an expression of their Jewish religious and ethnic identity. So demanding that a student shed any part of his or her Jewish identity as the price for admission is anti-Semitic. It's comparable to demanding that a Catholic student disavow the Vatican or a Muslim student shed his or her connection to Mecca. Excluding an individual in this manner on the basis of his or her identity is discrimination. My hope is that the Title VI complaint filed against NYU will help the university recognize this form of anti-Semitic discrimination. The university must do more to protect pro-Israel students on campus and ensure that they can safely express the Zionist part of their Jewish identity. One step that I've recommended universities take is to issue a statement recognizing that Zionism is an integral component of Jewish identity. The draft statement says, quote, "We condemn anti-Semitism in all its forms. We recognize that Zionism is a key component of the religious and ethnic identity of many students on our campus. Efforts to demonize Zionism and make these students feel unsafe expressing this religious and ethnic identity is contrary to our university's basic values of mutual respect and inclusion. Our university must be a place for the free and open exchange of ideas. It is never acceptable to harass, intimidate, marginalize, exclude, or demonize any part of our university community on the basis of identity." That's the statement. And I believe if NYU were to issue such a statement and truly internalize and apply its message, it would go a long way to improving the climate on campus for Zionist Jews.
Thank you, Alyza. Ben?
Well, I'll talk about the OCR complaint that the Lawfare Project filed against Columbia University last December, right after the executive order was signed, in fact. And basically, I imagine some or many of you are on various listservs with active members of the Zionist community. And if so, you've probably seen that for years, there has been talk of Columbia and what a problematic situation it has been there. But for better or worse, for years, it did not seem to us, at least at the Lawfare Project, that the situation had gotten to the point where it was appropriate to file a Title VI complaint with the Office for Civil Rights or otherwise pursue Title VI action. Much as we did not like what was going on, we were not about to pursue what we thought was a losing complaint or potentially even I wouldn't say frivolous, but a weak complaint. And we also did not want to base a complaint primarily on protected speech, even though, as noted, some forms of protected speech are examples of what is considered to be anti-Semitism, but again, not exclusively prohibited by the IRA definition or the executive order. But we didn't want to get into that until we thought it was a strong enough case. And so we filed in December on behalf of one particular student who had been just subject to demonization by professors in class. One professor was even lauding a designated terrorist group in class that a member of which murdered this student's uncle, who was an Israeli soldier at the time, and then made some statements singling out that student. Another professor walked by this student, the complainant, on campus and said, "Don't believe a word he is saying. He is Mossad," accusing him of being a spy. Excuse me. And the examples are just numerous. I don't want to bore everybody with them now, though I'm happy to later if you're interested. But events, pro-Israel and Jewish events being disrupted, and even as far as protests, and I would say not just a protest in an appropriate place, but a disruptive protest on Holocaust Remembrance Day that actually silenced a Jewish students' event to commemorate that day. And threats of violence from members of groups like SJP targeting Jewish students. Major crowds of SJP members just going up and surrounding known Jewish and Israeli students on campus and yelling, "Baby killer, get the F off our campus," all these terrible things at them every day. You know, that really got to the point of, we think, targeted harassment, not just making statements about Israel that we might not like, but targeting individual Jewish students and many individual Jewish students with this kind of treatment. And more importantly, though, is the fact that these issues were brought to the school many, many, many times. The Lawfare Project actually worked with one of these student groups several years ago to prepare a complaint to be brought to the relevant administrators in hopes that they would finally do something. And time again, the administration at Columbia has done absolutely nothing. Some of you may have seen that somewhat recently, in the past, I believe in this March, Lee Bollinger, the president of Columbia, announced that he has become increasingly concerned about anti-Semitism. And he even acknowledged that Jewish students are feeling hatred, demonization, invidious discrimination. And he says it's wrong. And that's terrific on the one hand. It's good that he is finally acknowledging it, but that's not enough. And that's why complaints or other legal actions are necessary when the schools simply don't do anything that they have the power to do. So, so while we applaud Bollinger for what he said, and we applaud other heads of universities for making statements that do acknowledge that anti-Semitism is present and is a problem, that's simply not enough, particularly when you have this ongoing pattern of disparate treatment and, again, harassment and intimidation targeting specific students that gets ignored.
Thank you. Joe?
So I promised in my opening that I'd be sharing examples where complaints citing the definition were really demanding censorship. And I'd like to kind of deliver on my word. So I'm going to kind of catalog a few. The director of the Masters of Public Administration program at San Jose State University referenced the definition while opposing a presentation of a lecture titled, "We Will Not Be Silenced, the Academic Repression of Israel's Critics." So, I mean, we'll take a second to let the irony sit in there. And in that opposition, this director invoked the specter of raising a civil rights claim under Title VI against the university if they didn't reorganize the lecture to present, you know, a quote unquote more balanced approach. Now, I certainly love more balanced approaches and like more voices to get to be heard, but we don't have to, in this event, have Palestine Legal or anyone else if we don't want to present different arguments. You know, if a school was not allowing others to present themselves, that's different from saying each time you present, you must present, you know, both sides. If you have an Israeli ambassador today, at that same day, at that same event, you must, you know, have someone from this organization. It's never worked that way. So that's, you know, one example. Students at UC Berkeley filed a claim with OCR because they perceived that a vigil that jointly commemorated the deaths of the 11 people killed in Pittsburgh at the Tree of Life Synagogue, with 3 Gaza, you know, children killed in Gaza by an Israeli missile strike, as being anti-Semitic under the definition used, and we're asking for the Department of Education to intervene and sanction the school for allowing that to happen. There have been a rash, and I mean a rash, of members of Congress who have written to the Department of Education asking them to open investigations, citing the definition, with a tremendous amount of protected speech being at the heart of their evidence of a hostile environment that they claim. And, you know, some of the letters have been under, and this will be confusing for a moment, Title VI of the HEA instead of Title VI of the Civil Rights Act, which are different entities, which I know is confusing since they're both called Title VI. But at least in one of the letters, the one from Gosar about the University of Arizona, it suggested that the presence of faculty making anti-Israel arguments itself should jeopardize all of the funding of the institution under Title VI of the Civil Rights Act, the one we've been discussing more today. So I throw that out there for your consideration because I would argue that it is not a bug of the use of the definition this way. It is the driving force behind using the definition in this particular context.
Thank you. Well, I'm going to turn it over to Mike for the last question.
Great. And maybe for this last one, why don't we reverse the order of the responses, and Joe, you can lead off. So the question, final question is, how might government involvement interfere with campus open inquiry and free expression? Is federalizing, quote unquote, and quote unquote, legalizing the problem of anti-Semitism on campus an effective approach?
I didn't realize I was muted. Thank you for throwing the floor back to me. I don't know that the problem is necessarily the federalization of addressing anti-Semitism. There's definitely a productive role governments at all levels can place in addressing anti-Semitism, as it can in addressing other forms of discrimination, and that's entirely appropriate. What we would do is we would codify, not just through an executive order, but through a statute in Congress that I think has more staying power, the part of the EO we said we agreed upon in terms of adding the cultural and stereotypes as a rule of construction of how to interpret Title VI. We would also add religion as a protected class for anti-harassment purposes under federal statute, not by amending the current statutes, but by codifying the standard of when speech crosses the threshold into no longer being protected, the one that's used in Davis versus Monroe County Board of Education, currently at the heart of the Title IX disputes, while applying it to any protected class covered under any of the federal anti-discrimination statutes, which again would shoehorn in religion without opening up Title VI or others for potentially unproductive amendments. And that's how we would deal with the legal half. But the second and more interesting question is the legal half enough, or is more needed? And I think it's obvious that more is needed. More education and more programming about the history of anti-Semitism and how it's unfolded. I would couple it with things about the history of other forms of bigotry, including Islamophobia, to talk about how cohesively we need to work together. And I think more dialogue, as Alyza pointed out, is necessary. And there are actors on both sides of the fence who are resistant to engage with people who they view as irredeemable enemies of each other, and that just can't continue. And we need to call out that from either side.
Thanks, Joe. Ben, do you want to go next?
Sure. I also think it's crucial that that religion be added as a protected class for purposes of federal civil rights law. It is possible that a lawsuit could be brought now under Title VI, and that a court would accept, as the Department of Education has, that Judaism, at least based on, again, shared ethnic characteristics, is a protected class. But it's also possible that a court could go the other way. Which is why I think it's very important for any lawyers who are taking on these types of cases or operating within this sphere to be very mindful of that, and to think carefully if and when they are bringing a case about how likely is it that they are going to succeed, or is it likely, to what degree foreseeable, that they're going to set bad precedent. Because the last thing we need is a court ruling that Title VI, as applied by the federal courts, does not protect does not protect Jews based on their in general, their religion, their shared ethnic characteristics, etc. I'm not worried, frankly, about the federal efforts to address these issues. I think they're very necessary because, as we've seen for years and years, schools are not doing anything on their own, or they're doing very little. Not every school, of course, but so many schools, which is why the current situations we see at many college campuses has gotten as bad as it is. Without these legal tools, even if it doesn't have to get as far as a lawsuit or an OCR complaint, again, I think that they serve as a deterrent to administrations to hopefully more and more identify when issues are problematic and implicate the executive order, Title VI, et cetera, and act accordingly. But again, it's also incumbent on schools and administrators to be educated in what these laws require and how they operate and how they can be enforced without violating the First Amendment. So again, and I realize I've stressed this several times, but if someone, for example, if you're dealing with a situation, a climate of anti-Semitism on campus, it's not up to the administrators to start going and expelling students for saying nasty things about Jews, or even statements that fall within the IRA definition of anti-Semitism, or to tell the people that they cannot host their event that includes such statements. What it is incumbent upon them to do is to take other measures as appropriate to ensure that Jewish students feel equal and welcome and safe on campus. That can mean hosting sensitivity training events, diversity events, putting more funding in to, let's say, hiring a faculty liaison for Jewish students, as we've seen happen at San Francisco State and some other schools. So again, I think it's most important that when the relevant officials at colleges are enforcing these laws, that they understand that there are ways to protect Jewish students and to make them to help when they are feeling marginalized, that don't go to the extent of silencing speech. Then you won't run into legal constitutional issues. And frankly, when we see administrators doing that, I think that will further deflate the arguments being presented that governmental moves or legislation like the executive order, that they are intent on suppressing differing views. So it really is, it's imperative to educate the enforcers of the rules, so shall we say, at school, so that they enforce those rules properly and effectively.
Thanks. I think that both Joe's answer and Ben's response show that there's actually somewhat of a faulty premise to this question. The notion that federalizing or legalizing the problem of anti-Semitism would be something new is not correct, right? The government's been involved in protecting citizens and students from discrimination in the form of civil rights legislation for many years. Title VI, which we've been talking about, was passed 56 years ago. Now, whether or not we should be trying to modify it, as Joe was suggesting, that may be one question, but I look at today, right? We have a problem on campus today. So how do we take the discrimination laws that already exist and use them to improve the climate on campus? Jews are a protected class. And the problem that we have today is that universities don't understand anti-Semitism. So they fail to recognize and adequately condemn the anti-Semitic vitriol. I don't disagree with Joe in that what they should be doing is condemning the anti-Semitism, not shutting down the speech, right? But the result of the failure to recognize and adequately condemn the anti-Semitic vitriol is that you end up with an atmosphere on these campuses where mainstream groups then conclude that it's acceptable to exclude Jews who refuse to shed a key component of their Jewish identity. Right? Why, for example, at the University of Illinois, should it be acceptable for the LGBT group there to demand that to be a member, you have to be an anti-Zionist? Why should the Jews have had to create an LGBT Jew group? Right? Separate is not equal. Why should the organizers of a Juneteenth rally just last Friday in New York think it's acceptable to advertise that rally as, quote, open to all minus cops and Zionists? Right? The public today, including many Jews, do not understand that you cannot support Jews but oppose Zionists. You can criticize the policies of the current government of Israel, but if you oppose Zionists, you're opposing Jews. If you marginalize and exclude Zionists, you are marginalizing and excluding Jews. Universities have to understand this, and quite frankly, Jews who are giving cover to the anti-Semites who say this also have to understand this. If it takes government regulation to ensure that universities protect Jews from discrimination the same way that they protect Blacks, Hispanics, and Muslims, that's not something for us to be unhappy about. Actually, I think that that's a reason to feel blessed that we live in a country which has such strong anti-discrimination laws.
Well, thank you very much. Thank you to all our panelists for addressing the 3 questions. You've given us a lot to think about. I think we're ready to get into our breakout rooms and begin a more intimate conversation. See you in a minute. You'll need to click join. I hope you enjoyed those too short. I wish we had 2 or 3 hours here. We don't get to have the coffee discussions and the drinks afterwards and the schmoozing, but I think a lot of important things were raised. What we want to do in the last 10 minutes of time that we have is to give each of the panelists a chance to say some final thoughts. What bubbled up from hearing your fellow panelists? What bubbled up from the breakout session that you think is important and vital for the participants to hear before we close? So chat is off and everyone's muted so that we can hear your final remarks. And maybe we'll start this time with Ben.
Sure, thank you. So I got cut off sort of in the middle of a question, but thank you, Marcia. That was a terrific question. I just think we need to understand better, and students need to understand better when it's appropriate to pursue, for example, Title VI action, or to expect that campus officials or faculty get involved in a situation and respond to it. And this can be tough because there is no bright line as far as there are some cases you could point to, but unless you were dealing with the exact same facts as another OCR complaint, let's say, that clearly that found that a violation of the law for allowing discrimination was patently apparent, you can't rely on something else. The facts of every situation, at least that we see, are quite different. So there really isn't a bright line. But I think it's important to educate faculty and students and everybody really about the First Amendment free speech concerns here, and that the fact that something may be offensive does not mean that it should be shut down. To really go through instances and to talk to lawyers if need be about these situations, and understand that yes, certain situations that involve speech may amount to the level that Title VI contemplates of severe and pervasive harassment and intimidation, et cetera, et cetera. But to really think about when that's, when certain instances of speech in particular are offensive, bigoted, et cetera, but are not actually impairing the ability of a student to participate fully on campus. And the reason I think that is so important is because you can believe that if a school was to start cracking down on anti-Israel speech harshly, they would probably, this is my guess, maybe I would be surprised and find out otherwise, but I think what that would lead to is anti-Zionist, pro-Palestinian students taking the same path rather, and trying to shut down Zionist speech, pro-Israel speech, bringing in IDF soldiers and others and Israeli officials under the guise or with the argument that these people are making them feel unsafe because by their very nature, they are somehow anti-Palestinian and a threat. And I think that schools are not, and campus officials are not wonderfully equipped, at least as of now, to be able to say, well, you feel unsafe because somebody's here, but they're not saying anything that is demonizing Palestinians, while at the same time, what your group is doing is explicitly demonizing and harassing individual Jewish students. I really worry, given the non-enforcement that we've seen over the years, that campus officials just won't know what to do with that, but may feel that if they are protecting one side, they have to protect the other, regardless of the fact that one side actually is deserving of protection under the law based on what the other side is doing. And, I hope I didn't make that, muddle that up at the end. But yeah, I worry about over suppression of speech based on the idea that, well, if we're going to protect one side, we have to protect the other side, even when the law doesn't require it.
Thank you. Joe?
Yeah, I agreed with a lot of what Ben just said. In fact, most of it. I think if there's a disagreement that we have, it isn't about any of what he said in his conclusion, but about our evaluation of whether or not the use of the definition fosters that environment where people are just going after each other for the protected speech. I think it does. I know that he doesn't think it does. But for the rest of the analysis, we're in a lot of agreement. I think that, I would say these are really difficult and thorny things because you are dealing with the intersection of protected speech, things that are core to people's identities, a legal framework that isn't so universal in that religion is not a protected class in higher education except for in admissions processes currently. And the Title VI shoehorn doesn't really add in religion so much as it adds ethnic and the cultural stereotypes that sometimes will apply in many of these cases. So there's a gap in the law as well in where it currently stands. I think in the long run, we need to be encouraging people to work together more rather than go the gotcha direction. And in that respect, I'd like to really second all of the things that Ben said along those lines. And thank you for having me.
Thank you. And Alyza?
There we go. So I think you'll find that there is quite a bit of agreement, but not all disagreement among us. I will say that in the breakout groups, I was asked to provide a copy of the statement that I suggested universities issue, and I will give that to you, Miriam, so you can distribute that if people find that helpful. And I do think that the important thing to remember is that not every unsettling incident on campus is grounds for a Title VI complaint. That's one of the things that I think we all agree on, right? In our country, the First Amendment protects even hate speech. But marginalizing and excluding students on the basis of their identity, I believe, is not a speech issue. That already crosses the line into harassment and discrimination. And it may be a difficult line to draw, but it's there. And we have to learn to articulate the difference. I believe you condemn the anti-Semitic speech, you punish the discriminatory conduct. And that's, I think it's important. We work with students and we tell them to document. And the question is not just documenting the anti-Semitic speech that's creating and fostering this environment, but they need to actually document the discrimination, right? They need to document whether or not or how they're feeling marginalized and excluded. Are they being shut out of student groups or campus events? Are their events being disrupted? Are they told they're not welcome, right? Are they afraid? Are they afraid to wear, as I said, any kind of distinguishing marks that show that they're Jewish, right? Are they afraid to wear a yarmulke or a Star of David or even t-shirts with Hebrew lettering on them because they're afraid that if they wear those, they'll be targeted and maligned, right? Students need to be, to know that the law is on their side and that they should be able to function on campus as proud Zionists, and that they shouldn't have to closet or hide or shed any part of their Jewish identity in order to be accepted. The law protects them, and we should be able to use the law in this way to help ensure that they have the space to be proud Jews.
Thank you so much to all three of you. And I want to turn to AN's Deputy Director, Mike Atkins, to close our webinar for today.
Thanks, Miriam, and thank you so much to our panelists, Alyza, Ben, and Joe. That was terrific. And thank you so much to all of you who joined and participated. I know that at least my breakout group, or the big breakout group that Ben led, that I was in, should say, some of the questions, there were further questions that we didn't have time for. We'll try to facilitate follow-up as best we can, we'll learn from this format, and hopefully things we'll have more time for the next one. But again, thank you so much. I hope this was useful to most of you or all of you, and we'll all see you soon.
Thank you.
Thank you.
Thanks, everybody. Have a good rest of your day.
You too.
too.
Thank you.